Hello, everyone, and thank you for joining us today for this webinar on Making Sense of Patents, presented by Foresight Senior Consultant, Dr. David McClure. As a registered patent attorney, David has worked on intellectual property for over the last 20 years in industry and law firms. In industry, he has managed patent portfolios, conducted transaction-related due diligence analyses, led license negotiations, advised C-suite teams on strategic alternatives for IP monetization, headed up R&D efforts to create first-in-category products, and overseen outside patent and litigation counsel. As outside counsel himself, he has advised corporate clients in pharmaceutical and medical device industries on designing around existing patents or establishing invalidity or unenforceability. He has also prepared countless patent applications and prosecuted them in the U.S. and overseen their prosecution globally. David has represented clients not only in proceedings before the U.S. Patent and Trademark Office, but also in infringement litigation and in licensing and settlement negotiations. Now, before we get started, I'd like to mention that your microphones will be muted throughout the duration of this webinar, so if you have any questions, please type them into the chat box and we will answer them during the Q&A session at the end. Also, upon completion, this webinar will be posted on our YouTube channel, Foresight Street, with closed captioning available for viewers who are deaf or hard of hearing. Again, thank you for joining us. At this point, I'm going to turn it over to you, David.
Thanks, Alyssa, and you're free to go ahead and go put up the second slide. This afternoon, we're going to talk a bit about patents, and in general, we'll go over rules to begin with. And rules seem kind of dry, but to make fullest sense of patents, you kind of need to figure out whether the patentee is following the rules the right way. And then we'll talk much more about what's related to technology commercialization, which is how claims capture value, and a few examples of that, and then some takeaways to think about. And just in passing, I want to mention that I'm happy to take questions through chat throughout this presentation. It's not excessively long, so there is plenty of time to ask questions. So feel free to chime in with questions through chat as you go along, and Alyssa will pass them along to me. So why don't we go on to the next slide. So in the larger context in which we're working at Foresight, we are guiding innovations to market, and our founder has always reminded us that in tech transfer, the goods being sold are intellectual property. And for intellectual property sales to take place, ultimately the enforcement mechanism of the state comes into play so that transactions can take place, be enforced. There's some reasonable expectation of going forward of possibly monetizing the intellectual property. And so this itself, in our jurisdiction, in our country, is not a new concept, because in the Constitution itself, as you see there in the second bullet, the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discovery. And so from the very beginning, the notion of monetizing for the public good intellectual property has been with us. And so when the Constitution speaks of exclusive rights, what are we talking about there? So let's go on to the next slide. And as is the case typically, the Constitution gets more detailed by the laws that Congress passes or the way that courts interpret them. And we'll talk about both those things today. But the core rights that accompany patents are described in this statute quoted here, 35 U.S.C. 271A. Whoever without authority makes, uses, offers to sell, or sells any patented invention within the United States or imports into the United States any patent invention during the term of the patent, therefore infringes the patent. So basically, to echo our founder's comments about the enforcement mechanism of the state being brought into play, an infringement action can take place if someone else is making, using, offering to sell, selling, or importing an invention that you have patented. So let's go on to the next slide then. These exclusive rights are not unlimited. So how are they limited? And The first part of this is what's terribly frustrating for so many of us in technology transfer. We try to figure out where rights are and where they're not. So in the United States is, of course, where our laws govern, but that's as far as the United States laws govern. And so if you're seeking to monetize your intellectual property internationally, you have to take further steps. And of course, we'll talk about those steps to some degree today. But not only are rights limited geographically, they're also limited in time. And the quoted section there from 35 U.S.C. 154 basically says that you get 20 years from the date of application. But if you look into the details there, it begins when the patent issues. That's when your rights begin, but they end 20 years after your earliest filing date. And again, what an earliest filing date is, it might be any of several things, and we'll go into some flavors of that. But the idea is you get substantive rights other than provisional rights when your patent issues, and they end 20 years after your earliest filing date. And I was asked today if we were going to talk about design patents. In passing, we will. And design patents, as you see there, have a shorter term, 15 years. And on to the next slide. So who gets these exclusive rights? And the statute itself, is rather broad. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. So that whoever is very broad, and it's quite literal there. So there's no requirement that invention have taken place in the United States or by a person who's ever been in the United States, for instance. And this notion of invention or discovery, we'll talk about a little bit more, because I'd say the second of those terms, discovers, is pretty much a dead letter at this point. But the super important part of this is new and useful, and we'll talk to some degree about what that is. But these four statutory classes of inventions: process, machine, manufacture, and composition of matter. And process, I think, is relatively self-explanatory. Machine, I'd say also. Manufacture is kind of an archaic term at this point. We might say product these days, a manufactured product. And finally, composition of matter itself is a chemical. And why don't we go on to the next slide then. So these two touchstones here, novelty and utility, they in the statute are teased out in different ways. So there isn't just strict novelty. You can think of novelty as having exactly the same invention, that a lack of novelty would be exactly the same invention that someone else has invented before. But if you've added an additional element to someone else's invention, your invention may be novel. However, if you do that, just simply add cream to hot tea or something like that, you might have made an invention that's novel, but it's obvious in view of what was known before. So obviousness is judged in view of all prior art, whether you know about it or not, and the knowledge of a person skilled in the art. And that differs vastly from complicated arts to supposedly simpler arts, and that is a case-by-case determination at the patent office and in courts as well. Now, I've lumped in, and this is a sort of non-standard analysis here, but as you'll see as we go through the presentation, this kind of works too. Utility, first of all, has to do with whether an invention falls into one of the categories of statutory subject matter. But as we'll see soon, that has been determined to some considerable degree by courts. And as well, because of this trade-off that we make, our system gives inventors exclusive rights in exchange for something. And what is that something that it's in exchange for? It's in exchange for an adequate description of what the inventor has done. So society gets the benefit of the description so that other members of society can improve upon what the inventor has done. So there's a way in which this utility to society is shown through the written description, and it is enabled through the written description. Why don't we go on to the next slide then? So what have the courts had to say about statutory subject matter? And as I say at the beginning of this slide, it's a moving target. This changes not just year to year, but month to month and case to case. But one thing is clear: an idea as such is not patentable. And I would go so far as to say here in the sub-bullet that even though the Constitution says discoveries are not patentable. There's no way they fit into the current understanding of statutory subject matter. So the Supreme Court has said that, okay, laws of nature are not patentable, physical phenomena are not patentable, abstract ideas are not patentable, but when they got a case for a genetically modified organism, they said, okay, that's patentable. But in recent years, as many of you know, that's been pulled back very much. So for instance, if you had a diagnostic process, or if you have a diagnostic process that's based solely upon a natural relationship between a drug dosage and a metabolite concentration, as was the case in this Mayo case, this was held to be just a transformation of an unpatentable law of nature. This is the Supreme Court. There's not a whole lot to be done about it. And so that is no longer considered to be patent-eligible subject matter, which, of course, was a blow to the diagnostics industry, which is nevertheless surviving. Now, also from the Myriad case, an unmodified natural product is not patentable. And then finally from Alice, which again is still playing out in case law being developed at the Federal Circuit, an algorithm as such was deemed not to be patentable by the Supreme Court. But as many of you know, perhaps all of you know, software is still patentable. They're just, you've got to be artful in the way you deal with it. So as you can tell, there are no bright line rules there about what is patentable, other than, I guess, from this gathering, in a genetically modified organism may be patentable, but we just know a lot of things aren't patentable.
So Dave, I'm just going to hop in because we do have a question about software patents that may be applicable here. What are the challenges today involved with patent applications that are primarily software programs and methods, and what techniques can be used to get software methods claims approved, for example, for a healthcare-related software program?
Okay, well, I'll try to address it in general and maybe come back to it at the end. There are certain categories of claims called means plus function claims, which have been used artfully for years, and with the most recent revisions to the Patent Act, there's more flexibility in using these claims. And before some of the recent case law in the Supreme Court, there was the notion that if you somehow machinized, and that's not really a word, but if you kept things not on the level of an abstract method, but you made sure some structure was recited, you'd actually be able to get protection even for software, say, residing in a structure. That no longer seems to be the case. So I'd say the trend is at least using, in some cases, this means plus function language. And again, this is a way you can describe in generality a process and then give several examples, several instantiations, and hope that that's sufficient support. And we'll talk a little bit more about support here in a minute. But that's the tentative answer, and I'm happy to take follow-up on that as we get to the Q&A at the end.
Wonderful. Thank you.
Thank you. So, yeah, let's talk about what a sufficient description of an invention is, because this really, this begins to be the bridge between just the rules of patents and how you determine value. And again, value it seems so ethereal, but let's look at how courts judge, or the Patent Office judges whether a description is adequate. And so you see in 112A there are several elements. First is a written description of the manner and process of making and using it, meaning the invention, in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or with which is most nearly connected to make and use the same. And finally, this so-called best mode requirement shall set forth the best mode contemplated by the inventor or joint inventor of carrying out the invention. Now, that speaks to the specification, but let's go on to B, and I'll come back to 112A. The specification concludes with claims. Now, there are all sorts of arguments about patent lawyers. Well, are the claims part of the specification or not? In a certain sense, it doesn't matter because you can't have a patent without claims because claims determine your property rights. And so you've got to have claims there. And the question then becomes, and if there's one thing I'm going to harp on this hour, is that you always have to determine whether the claims are adequately supported by the specification. And the way to determine that is whether those three requirements of 112A are met. And then finally, a claim may be written in independent or, the nature of the case admits, in dependent or multiple dependent form. So this is the idea is if you have an active pharmaceutical ingredient A, and in a certain, that's your claim one, the second claim might be the active pharmaceutical ingredient of claim one, wherein, or further comprising multiple excipients or something of that nature. So the idea is you add additional elements or limitations. And the more words you have in a patent claim, in general, you're going to have more elements or more limitations, which, of course, narrows the scope of your coverage. So keeping in mind there that, in general, within 112A, there are three requirements. The so-called written description requirement, which is basically to show you have possession of the invention. The enablement requirement, which is that you must teach how to make and use the invention. And finally, the best mode requirement, which has been, it's still there in the statute, but it has less teeth than it used to. But that's the subjective view of the inventor as what the best way is to carry out, or we might say today, practice the invention. So on to the next slide then. So, finally, where's the value? What does compliance with these requirements really do for us? Well, the most important point today, I'd say, is your claims need to cover or read on, the way patent attorneys would say, the way the invention will be used in practice. In other words, commercial embodiments, the way people do things in practice. And again, this is one of the many things our founder teaches us early when all of us here at Foresight go through training. We must envision how technology will be used in practice, or there's really no purpose in proceeding. So the claims must cover commercial embodiments, not just that are there now, but will be existing in the future. Second, the claims need to be supported by an adequate description in the specification, especially one that shows possession of the invention, that's the written description requirement, and shows enablement, in other words, teaches how to make and use the invention. So clearly, the greatest value is going to be derived when the specification describes thoroughly what the claims cover. And this is important when we talk a little bit as we go on about the life cycle of a patent, because there's one of the conversations I often have with clients and with non-clients is, okay, well, we've submitted the application, what do we do now? And of course, you have to wait, and I'll talk about what's involved in that way. But one thing's for sure, you can't substantively amend the specification adding new matter. You thought of another embodiment. Well, in a certain sense, it's kind of too bad if you do. You'll need to file another application if you thought of another way of doing what you have on file so far. But claims can always be amended during prosecution. And so I think a lot of when you're taking a critical view of patents, the idea is, well, make sure that you have enough in the specifications to support all the claims you want. And again, there are circumstances in which you can amend the specification, but they're typically just to meet formal requirements within the patent office. So on to the next slide. Another conversation I frequently have with clients and colleagues is, okay, well, what's the difference between freedom to operate and patentability? Well, I've talked a lot up to now about patentability. Something has to be new, useful, not obvious, and well described. But what enables you to determine whether you have freedom to operate or not? And freedom to operate basically is you're not on anybody else's turf. And so if your product doesn't read on any claim of any issued patent, that's currently enforced, you have freedom to operate. And of course, with such a categorical statement, it's really difficult for that to be a true statement, because how do you know for sure whether you read on any claim of any valid enforced patent? So you can't be sure. But if you want to try to be sure, do your best. It depends on how thoroughly you search, how crowded the field is, and how easy it is to identify prospective competitors. Because there are always improvements coming out, no matter what the technology area. So it's good to be diligent to identify who the competitors are and might be, and take it from there. So any patent attorney worth their salt is going to put all sorts of disclaimers if you're asking them for a freedom to operate opinion, because you can't know everything. And freedom to operate opinions are typically made on the basis of a particular embodiment of one's own product, and determining whether it reads on claims of issued patents. And as we all know, products are not etched in stone either. Forget patent claims. Not only is there a moving target out there about the scope of the art that you're measuring your invention against, of course, during the life cycle of any technology and any set of products, you're going to continue to improve on the product. So a valuable freedom to operate opinion may or may not take into account the fact that this particular embodiment that you yourself are working on now might change. And that's something really important to keep in mind, because all you can do with freedom to operate opinions at best is take a snapshot and hope you've got everything right. But the reality is that the circumstances change over the course of time. On to the next slide. Okay, well, patent searches. What is involved in patent searching? There are a number of ways that patent searches can be performed. Typically these days, there's some aspect that involves Boolean searches using keywords. And once you've identified, or you already know, because you might have patented in the area before, you know what patent classes are represented by your invention or inventions. You can search within those classifications, and alas, U.S. and international classifications are somewhat different from one another, so you have to kind of do double work there. And in my own practice, there are better and better tools for conducting chemical structure searches, but as with everything else in searching, they're not perfect yet, and I'm not sure they'll ever be. And so there are a number of ways to perform searches. So I think the thing to keep in mind with respect to searches is, what's the purpose of a search you're conducting? So for patentability, or to determine the validity or enforceability of a patent you might seek to challenge, all literature, including scholarly literature and even marketing materials, is potentially subject to search. Because again, you're trying to figure out if an invention is new, is it obvious in view of what's out there. So it's not just about patent literature, it's about everything that's out there. But for freedom to operate, the sort of the basic rule is, yeah, worry about patents because you want to make sure you're not on anybody else's turf. But the rest of that story is, of course, scholarly publications and other materials can give some clue as to what research groups are working on to develop IP for the future. And so I'd say for an FTO search, yeah, patents are in play now, but it's good to keep in mind that groups that have worked on particular technology in their area in the past are likely to return to it in the future, and that needs to be taken into account when assessing what the risk is of being on somebody else's turf going forward. Now on to the next slide. So at the simplest level, and I don't know how simplified to make this, there's sort of a basic patent life cycle. You can file a priority document, which in the United States is a provisional application, but that's not required. And then you can file after that, within 1 year of that priority document, a utility application or a patent cooperation treaty application, and we'll talk about that in a little bit. And 18 months after the priority date, publication will take place. And unless you're on a super fast track at the patent office, and there are some such fast tracks these days, you're typically not going to get a first office communication on the merits until after that time. It much depends on a lot of factors out of your control. And those office communications may tell you about informalities in your application that you can correct, such as drawings that are not according to the right protocol, or there may be a need to revise something else in the specification because it doesn't meet some formal requirement, although that's much rarer. And then typically these days, you can expect a restriction requirement telling you that you've got more than one invention you've claimed, and you must choose from among them which to prosecute first. And finally, once you start an office action on the merits, then you're going to get typically rejections, of course, on the basis of the four, again, hallmarks of patentability: utility, novelty, non-obviousness, and written description. And then once you receive a rejection, you have the opportunity to respond. And I pause there and put the beware in all caps because it's always good to be somewhat cautious in response, to amend as little as possible, because when you give up rights in the patent office, let's say you narrow the scope of your claims, it's very hard to recover that, and I'd say well nigh impossible these days. So you obviously want to try to argue on the law and the facts as much as possible before going in any way towards an amendment. So that's a good basic rule. It's not always possible to do that. Eventually, after multiple rounds of this, and in Q&A we could talk about how this typically goes, I suppose, but either you give up, which is rare because these days eventually it is possible to get issue. You have claims allowed and can get a patent issued on the basis of the claims that you've successfully prosecuted. And if those claims are allowed, you have to pay fees. And of course, at the beginning of this process, you paid fees for filing, for search, for publication. And for issue to take place, you have to pay additional fees. And then, of course, to keep the patent alive, and that's why I'm referring to this patent life cycle. It's not just getting to issue, but of course, there are going to be fees to be paid during the term of the patent as well. So let's go on to the next slide. And Alyssa, I'm having a little technology trouble here. Could you remind me of the title? I'm not seeing it on my screen.
Sure. It is the PCT process, simplified.
Sure. Yeah. Thanks so much, Alyssa. So in this instance, we have the typical patent cooperation treaty process, which is kind of similar to the U.S. process, but there's some bells and whistles that are super important. So after you file your priority document, you again have 12 months in which to file this patent cooperation treaty application, and you can select designated states all over the world at no additional charge. You can get your foot in the door, get the opportunity to file all over the world at this 12-month time. And then at 16 months, give or take, there will be some activity from the International Searching Authority. So when you've filed your patent cooperation treaty application, you can choose a particular International Searching Authority to perform a search on the basis of the application you filed. And there's, again, different practitioners have their favorites, but they're quite good searches to be done in any number of places in the world now. And basically the report of the search is sent out, as is a preliminary opinion, and at 18 months, give or take, there's publication of the application, and if it's ready yet, what the International Searching Authority has done. And then finally, at 30 months, there's the opportunity to file in various jurisdictions around the world. And again, with the there are places where you can file in one place to cover multiple countries, kind of beyond the scope of what we're going to talk about today. But anyway, the point is that approximately 30 months out from your priority date, you need to have your ducks in a row so you can prosecute in these different countries. And Alyssa, why don't we go on to the next slide, and feel free to tell me the title as well.
Sure. This is example 1, Apple versus Samsung.
Yeah, my technology has now cured itself, so thanks. So I want to go on to examples here of value extraction because, again, this has all been kind of theoretical up to now. So let's talk about where value's been found, and to a certain extent we could say why, although why questions are tough to answer. But when things got tough between Apple and Samsung in 11, first Apple was the first litigant, Samsung countersued, but when Apple had success in court, and these cases are still ongoing, they didn't just assert utility patents, but they actually asserted design patents. And as we all know, they must have spent a fair bit of time and money on designing the iPhone. And so certain of the design patents that they had issued covered, for instance, the rounded edges of the iPhone. And those were successfully asserted in court. So when I have, again, clients come to me and say, well, is it really worth getting a design patent or not? And of course, it always depends. But the point is there can be enormous value in design, even if it's, in fact, perhaps particularly when it's not utilitarian. And so in this case, it was certainly part of what Apple found helpful in court to assert those design patents against Samsung. And again, this litigation gone on all over the world, still going on in the United States. But certainly I'd say that Apple found there was value in these design patents. And on to the next slide, I bring this example up with regard to my sort of laborious description of written description requirement, in that it sometimes comes back to haunt you if you don't have a written description that's satisfying to courts. And forget the patent office, because this patent did issue, and it was a method for selectively inhibiting prostaglandin H synthase 2 activity in a human host, comprising administering a non-steroidal compound that selectively inhibits activity of the PGHS2 gene product to a human host in need of such treatment. And I read the claim there out loud because there's a fair bit of generality to it. Basically, if you administer an NSAID that selectively inhibits PGHS2 gene product, you're basically reading on this claim. And so it got through the patent office just fine, and then it was litigated. And so what the Federal Court of Appeals for the Federal Circuit didn't like about this is that no particular compound was recited or described in the specification which caused this selective inhibition. So they found, basically the result was the patent was invalid under the written description requirement of Section 112. And again, back to this trade-off of why I lump Section 112 into utility analysis of a patent. It's not strictly speaking whether the invention is useful, it's whether your disclosure is useful to society as well. So in order to get this exclusive right, in other words, you can exclude the public from your turf, you have to make a meaningful disclosure. And that was kind of the Federal Circuit's bottom line on this. This was not a sufficiently meaningful disclosure to say, okay, how can you, can I prove that I really have any such compound? Well, no, I can't, because it didn't make its way into my patent application. So the cautionary note here is, obviously you want to put as many examples in an application as you can, and preferably working examples. And not on the slide here, but what sort of part of the art of the patent practitioner is to make sure they inquire of the inventors as to all working examples, which become, again, actual examples is another name for them, which are described in past tense in patent applications, and then as well to work with the inventors to, again, tease out of their brains, well, how's this thing going to work in the future? So-called prophetic examples, which are described in present tense in patent applications. And it's really, I think, again, there's no perfect answer to what the right number of examples is. There's no particular requirement that there be even one. But case law tells us that the more examples you have, the better off you are. They don't always have to be working examples, and we'll get to that in a minute. Another note here, looking on the second line of that claim, just notice the transitional word comprising. And as perhaps all of you know, but just by way of reminder, comprising means including at least what follows. And so the sort of polar opposite of it within patent language is consisting of. And consisting of means basically including only what is now stated. So comprising is a so-called open-ended transitional word, and that is certainly what you like to have when you prosecute claims. And consisting of, it certainly has value as well, but when you're looking at claims quickly, like many of us have to do, it's nice to see the word comprising there. And of course, that also opens up the universe to more invalidating art, because if you come up with something seeking to invalidate a claim such as this that has such open-ended language, it might make it a little bit easier to find invalidating art that actually anticipates the claimed invention. So let me go on to the next slide here.
So I'm just going to interrupt you real quick here, Dave.
Yeah.
So we got a question. Actually, more of a statement. Sounds like PGHS2 claim was more designed to shut down research by competitors than to actually protect the specific product. Comments?
Well, research can go on notwithstanding really great patent claims, and again, there's sort of a court-created sorts of exceptions for research. So I don't know that that was the purpose. It certainly was a great broad claim, and I appreciate that comment. I think there's something to be said for it. But I think it was audacious and properly so, because it was a big deal that these the inhibitors of COX-2 or whatever the enzyme was were out there. So I mean, it was good to try to keep out competitors. I'm not sure it would shut down research, but it might have kept other competitors off the market had they been successful. So I think that's a great question. I think for the most part, research is not prevented by patents, but those making, using, selling, offering to sell, and importing are. And again, you say, well, isn't research indeed use? Well, it is, but a lot of research is done under the radar, and publications take place. And what's the damage then if somebody's published on something using your patented invention? There may not be any damage at all. So a really good comment there, and appreciate it, but I doubt it would ever have been able to shut down research.
Okay, great.
Now to a successful attempt to extract value from a general description. And again, first of all, you notice even here, as always, patent attorneys, you ask two of them a question, you get three answers. But here, instead of using the word comprising, it's which comprises, which again is just artful drafting. I'm not saying it's any different from comprising, but you see which comprises is sort of the fulcrum there. So here we have a method for replicating a biologically functional DNA, and I won't read the entire claim here, but there's certain elements of it here: transforming, then cleaving, then combining, and this sounds a whole lot like the cloning that's been done for the past 40 plus years, and indeed it is. And this is really one of the seminal patents of Boyer and Cohen, which described the process in generality, had a few working examples, and had some prophetic examples in it. And this was successfully licensed by, was managed by Stanford, but to the benefit of both Stanford and the University of California, garnering $200 million, it's estimated, in licensing revenues over the course of the patent family's life. So again, not so much to try to contrast this as such from the patent of the previous slide, it's just that you have a method here that is described in generality, and it was expected to be practiced once the reagents were available for everybody to practice it across the world, and indeed that guess was right. And so the value of the generality of the method was captured in this and other claims, and they were successfully out-licensed, and I'd say, again, to great public benefit everywhere. So did not, and again, to follow up further on the previous comment, the fact that this patent was enforced certainly didn't shut down molecular biology research. In fact, I'd say quite the contrary. It made a business of molecular biology research, and again, there's been great public benefit that's accrued. And let's go on to the next slide then. And once this presentation concludes, you can go back and look at these two slides in tandem here. But basically, we have two slides in a row. And Alyssa, if you want to just advance to the next one and then come back to this one, it's fine. But there are two alternative universes that most of you, if not all of you, are aware these days, in which gene editing patents are being pursued. And so the first example there is from Dr. Zhang of the Broad, and this is the claim that went through the patent office under an interference that you probably read about or not were involved in, that was resolved, I guess, in 2016. But basically, for this eukaryotic application of gene editing, despite the declaration of an interference, this claim was found valid. And so this is sort of part of the beginning of the Broad Institute's and others' estate in gene editing. And then looking at the following slide there, you see there's a more, I don't want to say that, but there is a general method of, and you could see the recitation there. There's nothing that's necessarily limiting this second claim here to a eukaryotic cell. So this is a very general claim of the Duden and Charpentier group. And I'm asked all the time, well, how can they both be valid? And again, the patent lawyer perspective on this is that, really not a problem, because the Zhang claim, again, is directed to eukaryotic cells, or use in eukaryotic cells, and the Duden and Charpentier claim is directed to basically just a more general method. And time will tell, and there's going to be litigation all over the world about this, certainly. Time will tell where the value is, but I'd say there's certainly value in each one. How this plays out, nobody knows. But they're I shouldn't use the word complementary. They're two different ways of describing something. And again, evidently, what you read in the press, there's support from each group's research and what's in the specifications, which you can now read online. There's support there for the claims, and whether in litigation long-term they'll hold up, I don't think anybody knows, but there's certainly so much value in gene editing that we're going to find out sooner or later. I'll go on to the next slide then. Final points to consider. So one thing I hope I make clear is that there really aren't a lot of yes-no answers to these things. There are a lot of ifs, ands, and buts. You have to think about a lot of things to determine whether your claims are really capturing the value you want them to. But one thing I can say is just never look at the specification or claims in isolation. The important question is, the claims cover commercial embodiments both now and in the future, and does the specification support the claims? Another important takeaway is when you're doing patent searches, especially for novelty, in other words, for those of us involved with technology transfer, we're trying to advise those we work with on, yeah, this is a great idea to go forward with or not, and here's why. Well, don't forget that you lose novelty, not just if there's a patent out there describing the same thing, but if there's a publication of any sort out there describing the same thing. And so it's very important to search non-patent literature when you're conducting novelty and also invalidity searches. Okay, and then next, the assessment of freedom to operate is not an exact science. And you need to take into account not just issued patents, and they're the core of what you do in an FTO search, but also think about pending patents and what's going on with those. And if there are any questions about that, I can talk about how you monitor the progress of patents in the patent office. And even the possibility of yet to be published applications. And as I've suggested, you're not going to get clear answers here, but you're going to figure out a little bit better what shade of gray you're in. And that's important when you're making strategic choices, because there are always limited resources and you have to figure out where to allocate them. And then finally, most important take home, and I'd say I'd like to think of this as one of the the happy lessons of the Boyer-Cohen patents. I mean, it does be collaborative, look for collective global use of what you're working on, because that's where you can create a lot of value, and it's value that truly benefits society, not just in your own tech transfer office or in your own practice, but for people you're never going to meet. So it really does take a lot of effort, and different individuals and different groups' efforts to take an invention that's just on paper to being commercial products for the public benefit, but it's a worthwhile endeavor, and I think those of us who work in the field are happy to be involved. And with that, I'll stop and take any more questions that might be chatted through, Alyssa.
Okay, wonderful. So we do have lots of questions that already came in, so I'm going to go through those now. If you do have any more questions, feel free to type them into the chat box, and we'll try to get to them. If we do not get to all of the questions, then we'll answer them offline via email. So we'll start with the ones that we got early on in the webinar here, although they may have already been answered by now. But okay, so how is an inventor defined?
To a first approximation, the person who conceives of and reduces to practice an invention. And the important part, the part that can't be done without, is the conception. The reduction to practice, which is either the making it real through a real example or making it into a prophetic example through writing, that's the part that's, I won't say it's iffier, but you can supervise others in the reduction to practice and still be reckoned an inventor. I'll stop with that, and I'm happy to take follow-up, and with my contact there, if you have any questions about that, feel free to follow up.
Okay, can claims tracked to inventors be taken out and the inventor removed from the application?
Well, the short answer is yes. Another great question. All these questions are very, very good. The inventorship is determined claim by claim, and so if you're prosecuting claims that no longer were invented by one of the named inventors, of course, you may remove the inventor from the application.
Okay, excellent. Are there some practical definitions of obvious that will help guide inventors?
Another great question. I would say no. It's the bane of my existence, and I think of other practitioners as well, because everything appears obvious in hindsight, and that's, of course, when the patent office and the courts are getting hold of these things. So it's a very good question. And the standard answer is you're supposed to put yourself in the position of someone skilled in the art and figure out, well, would this have been obvious? And my answer typically is, well, if someone would have done it before, had it been obvious. So I wish I could answer that question with substance, but even to this day, after having done this for 20 years, I can't.
Okay. Let's see. How much legal leverage does a small company have against a large company who is using their pending or issued patent in their product?
The short answer is not a whole lot, but again, I think there are ways that I think that the conversation needs to take place regardless. I mean, that one owes duties to one's stakeholders when in a small company, and I think one of those duties may run to trying to extract value from something that you spent money on patenting or having a pending patent on. So it's a really good question. There isn't a whole lot of leverage, but I think the effort is warranted.
Okay, great. If a company files and then abandons a provisional patent application, is that material considered prior art? Same question goes for a non-provisional.
Well, the usual answer for the second would be it depends. Provisionals never see the light of day, and so in general, they are not considered to be prior art, and I say in general because there are always exceptions. And let's just say by hypothesis, the non-provisional was not published, then the same answer would apply. Now, if you get to things that are published, then of course that's a completely different situation. That's the short answer. But all provisionals are abandoned by operation of law. I didn't dwell on that, but provisionals go away after 12 months regardless. I mean, there's supposed to be a mechanism by which a provisional can be turned into another sort of application, but it's rarely used, and I don't see any it's never been clear to me why someone would choose to do that. You just follow it up with a non-provisional application. But I am not aware of any circumstance in which a provisional that never saw the light of day was reckoned to be prior art. And again, there are always exceptions, but I'm not aware of one.
Okay. Can products that have a unique application and is purposeful in use are made by off-the-shelf parts with very few unique parts be patentable?
This is a very practical question, and I'd say it's possible. That's often the case. I think it's a challenge, but there's no reason to say no. And I think when you're evaluating whether to go forward or not, you just have to make the argument to yourself, well, how would I try to convince myself this is not obvious in view of what was out there? And it could be, again, the typical answer is, well, the results of doing this were quite unexpected, but it's worth going through that exercise. I mean, if you can't even convince yourself, obviously it's going to be difficult to convince the patent office or courts, but that's the question you need to ask.
Okay. Does medical SW fall under FDA approval?
Kind of off topic, and I appreciate the question. It depends on whether, I mean, first of all, this is harkens back to another seminar from the past, but software may or may not be subject to regulation, and FDA's done a lot by way of promulgation of guidance documents in the past few years to tell you a little bit more clearly what's subject to regulation and what isn't. But I mean, software that runs, an MRI, you can imagine might be regulated a little bit differently from an app that goes with a wearable which doesn't have some sort of life-supporting condition. So I would say there's not a clear, unified answer to that question, but it's possible the software may be regulated, and it's also possible that FDA declines to regulate it because it's not one of their priorities. So it really depends on, as you might recall, if any of you attended the last webinar, it depends on the intended use of the software and its risk profile.
Great. And just to follow up on what Dr. McClure was saying is we did our past webinar on FDA approvals and regulatory approvals. So you can find that webinar on our YouTube channel. The link is on the screen here now. So if you want to check that out if you were not a part of that webinar. Okay, so next question. At the beginning of the patent cycle, doesn't the specifications requirement include patent figures?
It depends. If I've filed lots of patent applications and seen many patents issued without figures, but that doesn't mean they're not helpful. So for certain inventions, I guess you could say they're essentially an absolute requirement. Yeah, you're right. But it is not the case that the statute requires a figure for every invention. It does not.
Okay. Is it advisable to apply for a patent on your own through LegalZoom, or do you really have to hire a patent attorney?
Probably on the slide it says not legal advice, right? So I'm probably going to avoid that question. I think the important thing is, even if whether you prosecute a patent yourself or you work with an attorney, the important thing is to educate yourself about the rules, because you don't want to take anybody's advice. If suppose you went to an attorney, you don't want to take their advice blindly anyway. You'd want to educate yourself about what the rules are and how they apply to your particular situation. So I have no quarrel with those out there providing services, but your job, and I tell this to my clients all the time, I just say my job is to give you a lot of homework, because there's a lot for you to learn as you're going through this, and those who learn it successfully can end up doing very well, getting their invention not just patented but out to market.
Okay, great. It looks like we've got time for one more question here. Kind of a general question, actually. Can you briefly discuss your header, copyright ? Without the R or C symbol? So just kind of a general question.
Sure. First of all, again, outside the scope of today's webinar, but copyright subsists, that's the statutory word. It happens automatically, so I don't have to put copyright rather than the C circle there, which provides notice. So copyright happens when a work is created regardless. So there's no statutory requirement these days that there be the circle C. And with regard to the circle R, of course, that's for registered trademarks, and I have no such thing, so it didn't belong.
Okay, great. So that looks like all the time we have here. We do still have a couple extra questions. If we didn't get to your questions, we will respond to you by email. If you come across any additional questions or you've thought of something else while we were answering these ones, feel free to reach out to us. Either David's email is on the screen, or you can reach out to me, Alyssa Naswis. I was the one who invited you to this. This webinar will be available on our YouTube channel, Foresight Street, where you can find this and lots more commercialization content, tutorials, webinars like this. We hope that you'll join us for future webinars. And as I said, feel free to reach out to us if you have any questions about this or any other commercialization issues you're having. We'd be happy to answer them. Again, thank you everybody for joining us, and of course, thank you, Dr. McClure, for this wonderful presentation. Everybody have a great day.